I am here at the Supreme Court building in the Solicitor General's office with Justice Samuel Anthony Alito, Jr. Do you use the full name usually?
Not most of the time, no. Just Samuel Alito is fine.
Okay. And we're going to talk a little bit about legal writing and writing in general. I wanted to ask you, first of all, at what point in your schooling did you make the greatest strides as a writer?
It was before I got to college, probably in junior high school and high school, maybe even to some degree in elementary school. My father had been a high school English teacher, among other things, and he was really the person who did the most to teach me how to write. Whenever I had a composition for school, we would go over it, and he would pick apart every sentence and every choice of words, that's whatever I've learned. Most of it, I think, was the result of that. Sometimes pretty painful experience.
Did you grow up, as I did, in a household in which over the dinner table grammar would be corrected and there was this fastidiousness about language?
Oh, absolutely, yes. I still remember some of the things that my father would say. If we ever said, we ever misused the word healthy as opposed to healthful, we would be corrected for that. And there were a whole list of them.
Is that something you still observe?
Yes, it's ingrained in me.
Was your mother also interested in language?
She was. She was an elementary school teacher. And so I think she spent a lot of time with me on schoolwork and on writing when I was in elementary grades. And then I guess when I moved on to the upper grades, she sort of handed off that responsibility to my father.
When you, after high school, were there other sort of growth spurts that you went through as a writer?
I think really most of what I learned, I learned prior to college. Of course, I hope I've improved a bit over the years. But I think the focus of, and I did a lot of writing in college and some writing in law school, and that was a good experience. But my experience was that in college, and certainly in law school, much less attention was paid by the professors or whoever was reading whatever you wrote to the quality of the writing per se, as opposed to the substance of what you were saying.
Mm-hmm. How important do you think it is that lawyers write well?
I think it's extremely important. Certainly, I appreciate good writing. It makes my job so much easier. I've seen briefs that are extremely well written and some that are abysmally written. And it sometimes, the first quality, of course, that's necessary in writing is clarity, so that you can understand what the lawyer is trying to say. If it's elegant, that's a plus. But if I could simply get clarity so that I can understand what they're trying to say without a great strain, that's a help. And I remember something my father would often say about writing. He said, sometimes when you're having difficulty expressing something, it's because you really don't know exactly what you're going to say. I think there is a clear relationship between good, clear writing and good, clear thinking. And if you don't have one, it's very hard to have the other.
A lot of people seem to start writing before they quite know what they want to say, don't they?
They do, and I think that's a mistake. I can sometimes see briefs and draft opinions and sometimes things that my own children write that I review that I think were written that way. I think you have to have a good idea of what you're going to say and the order in which you're going to say it before you actually start writing.
What do you think about the view that some people say, well, how do I know what I think until I see what I ended up saying? Is that kind of writing to discover what you think something that can be useful, but you need to junk all that stuff and just start anew?
I think so. I think no matter how carefully you plan what you're going to write, some of what you just described will often occur during the writing process. And it goes back to my point about the relationship between language and thought. Judges often say you just wouldn't write. And what they mean is that when you have to go through the discipline of actually putting your argument in written form, you see problems with what you had thought out. When you're just thinking about a legal problem, your mind can easily skip over problems. When you have to write it, and if you aim for a tightly reasoned, well-expressed argument, very often that will expose the problems in the kind of argument that you had anticipated you were going to make.
When you were on the Third Circuit, how often would you discover that the opinion just won't write and it's going to have to turn out differently?
It happened occasionally, not most of the time, but occasionally it did. There were instances where I was assigned to write an opinion going one way, affirming or reversing, and when I worked on it, I found that I changed my mind, and I actually wrote an opinion coming out the other way. And usually in those instances, I was able to persuade the court to go along with what I had decided during the writing process.
I would imagine that that would happen much less frequently on the Supreme Court, as well vetted as all the cases are. Has it happened at all since you've been here?
It has not, no.
Mm-hmm.
But I think it certainly can happen.
What did you learn from your clerkship with Judge Leonard Garth on the Third Circuit?
Well, I learned many things. He was a wonderful mentor in many respects. If I had to pick just one lesson, I guess it was to pay very close attention to the specifics of the case that was at hand. He was an old trial judge, a trial lawyer. He cared a lot about the specifics of the case, paying very close attention to the record in the case, and I've certainly taken that from the experience.
Was a clerkship in those days pretty much what you think of a federal appellate clerkship as being today?
It was.
Mm-hmm.
There were some differences in the way we worked. We didn't have word processing, for example, but the substance of it was pretty much the same as it is now.
What is the best use of law clerks?
Well, I use them for the two main categories of work that I do: deciding the case, deciding how I'm going to vote, and then working on the opinions. I think you have to use them. I think you have to use them in both of those ways.
What did you learn about advocacy from working with Rex Lee at the SG's office?
Rex was a tremendous oral advocate. We didn't do a lot of work together on written submissions, but I heard him argue, and he had a very matter-of-fact, down-to-earth, plain-spoken manner, but he was extremely persuasive in making his arguments that way. I think that's very helpful.
What are the most overlooked tips on oral argument?
Simplify. I think that's simplify, summarize, synthesize. I think those are, and be prepared to understand exactly what the point that you want to make, the exact contours of the argument that you are making, the borders of your argument. Those are what's most important. You don't have very much time, and the way oral argument is presented today, the answering of questions is really the most important part. There's not a lot of making pretty speeches any longer in oral argument. So you have to be prepared to answer all the tough questions. And then the really great advocates that I see, including a lot of people who appear before our court, have a tremendous ability to stand up, let's say in a rebuttal where they may have 2 minutes, and summarize all the important points they want to make at the very end of the case in a coherent form in just those 2 or 3 minutes. I don't know whether people who see that performance understand how difficult it is, but it's very hard, and I think very helpful in leaving the court with the impression that you want.
Isn't that one of the key skills that lawyers need, and probably a great rarity, is a really good ability to summarize?
It is an awful lot of, and to simplify, and to leave out the things that are just not important. Of course, you don't want to leave out anything that is important or distort the facts of the case or the law or the argument that you're making, but it takes a real discipline to say, this really isn't important and that really isn't important. So often, a mediocre brief will have all sorts of extraneous things in it. And it just makes it more complicated for the reader to understand, and I think it lead to sloppy thinking also on the part of the lawyer. If you really identify what is important and start pushing away all the things that aren't important, what you're left with that's what you want to present to the court, and I think it helps you in making your argument if you do that.
It probably requires lawyerly judgment, and it's a hard thing, isn't it, to simplify as far as possible, but never go so far as to oversimplify.
It is. It absolutely is. But I'll just give you just a simple example, a mundane example that comes up all the time. You will get, I used to get on the Court of Appeals, a little bit less here, lots of briefs and draft opinions, all full of dates. And the dates were totally irrelevant. Why did you need to know that something happened on March the 2nd, 2007? Now, of course, if there's a statute of limitations issue or something like that, and then you have to put the date in, and the one date that you put in will stand out. But on such and such a date, such and such a motion was filed. It's all, generally it's of no importance whatsoever, and yet it complicates what you've written.
Why is that in particular such an endemic problem among legal writers?
I don't know. I think it's just easy. It's easy to do that. It's just to put in a lot of unnecessary details, to give the facts of the case and put in a lot of unnecessary facts, to recount the procedural history and recount all sorts of things that have dropped out of the case and they're not any longer important on appeal. It's just easier to write all that, and probably the brief should have gone through 2 or 3 more drafts, and each time things that were not important should have been excised. But it's the old adage, if I had more time, I would have written less. A lot of time people just don't have the time, or they will not devote the time to the project that it really should require.
When you write a judicial opinion, what readers do you have in mind?
That's changed a little bit here. I think we have a much broader readership here. Certainly, I have on the Court of Appeals, I had in mind principally the lower courts and lawyers in future cases who would read the opinion. We would write the opinion if it's what we used to call published opinion as precedent. So I wanted to try to speak clearly to them so that they would understand what we were holding, and they could apply that and be guided by that in future cases. I had in mind certainly the parties in the case. I wanted to respond to their arguments and show that their arguments had been given careful consideration, and if we disagreed with them, so that I wanted them to understand why we disagreed. Here we have a somewhat broader audience, which makes it, I think, more difficult to write, because we are writing most of the time on very technical subjects. And if you are just writing for lawyers who are knowledgeable in the field, you leave out a lot of things that are understood. Ordinary people reading that won't understand if you leave out too much, and they may also get a mistaken impression about your attitude toward the case, because things are understood among lawyers that are not understood by lay people, intelligent, articulate lay people reading a judicial opinion.
Do you think opinions tend to be too long?
They do. I think in general they could be shortened. I'm sure mine could be shortened. Again, I think it's mostly a matter of time and energy. It is the process of shortening it's work. It's time consuming, and it requires mental energy to do it.